All right, let's get started. This is François Gay. I'm the founder of the Canadian Cyber Security Network. We have an amazing session today. We are going to talk about inside a cyber breach, lessons from the insurance, legal, and IR war room. This is going to be great because we've got a mix of both practitioners, individuals from the industry, a customer. So we've got an opportunity to really have a live conversation here and for people to learn and to better understand what actually happens. So that's going to be fantastic. Next month, we have a wonderful session from BSI Group, NCCN, that's going to be on ISO 27701 and ISO 27701, which is strengthening the data security and privacy in healthcare. That, again, will be a very dynamic session. So there should be a lot of learning opportunities. So I'm going to pass it over to Sophia Miller. And she's going to take over, and we'll see everybody a bit later.
Thanks so much, Francois. Hello, everyone, and welcome. I'm Dr. Sophia Mueller, and I'm delighted to be your moderator for our discussion today. Today's discussion brings together three experts who work on the front lines when cyber incidents strike, each offering a unique and critical perspective. We're joined today by Mohammed Jama, partner and vice president at Jones DesLauriers Insurance Management, who will walk us through the evolving role of cyber insurance. Sean Ford, partner at Ceiba Law, joining us in his capacity as a seasoned cyber breach coach to highlight the legal and regulatory minefields organizations must navigate, and Jarrett Perrin, CEO and national lead at C3SA, who will take us inside the technical incident response process and show where swift action can make all the difference. Together, we'll step inside a real-world style cyber war room, unpack common missteps, and show you how to reduce pain, cost, and chaos during a cyber incident. We'll begin with a brief overview of today's cyber threat landscape before diving into a simulated breach scenario. Our panelists will share how insurance, legal, and technical teams come together under pressure and what lessons you can take back to your organization to be better prepared. Throughout the session, we encourage you to submit your questions in the chat. We'll do our best to address a few at the end of the discussion, and any we don't get to today, we'll follow up afterwards. Please be sure to include your name with your question. Let's dive in. So cyber incidents are no longer hypothetical. The question is if not if, but when, and what your organization does in the hours and days that follow can make or break your recovery. Let's set the stage with a high-level look at the current threat landscape, explore how cyber insurance is evolving, and examine shifting legal exposures, and consider the operational pressure businesses are facing today. Let's begin with Mohammed. From the insurance perspective, what are you seeing in the Canadian market right now? How has cyber coverage evolved, and what trends should businesses be paying attention to?
Thanks, Sophia. That's actually a good question. If we're looking at the last decade, cyber insurance has significantly evolved, not just from a pricing and coverage standpoint, but also from an underwriting standpoint. Underwriting in the sense that, underwriters have become more sophisticated from an insurance standpoint, asking the right questions to clients to make sure that they're pricing and taking in cyber risk effectively. If we look at now in the short term, over the last, I'd say, a year and a half now, since February of 2024, the cyber insurance market has taken a significant shift to the betterment of the client. Since COVID, all the way to February of last year, pricing has always been going up for clients year over year. Coverages have become more restrictive in certain cases, depending on the type of controls you've had in place. But since February, the favor and the ball is back in your court. And that's because we've hit what you call a soft market for cyber. Soft market, again, rates and coverages are in your favor. And if you're working with a sophisticated cyber insurance professional, it's the best time to take advantage of the actual industry to get better terms and conditions for yourself and save some premium. Why is this more important to the cybersecurity world and service providers out there? This is a good time for you to offset some of the costs that are associated with premium by transferring some costs over to technology from a people, process, and resilience standpoint, especially when it comes to reinvesting in those spaces as well. So that's as a high level where we are right now.
So, Mohammed, that's some really good news. And Sean, I do believe that there's some significant shifts happening with regards to legal obligations as well. What's changing in breach notification law, and how should companies be thinking about legal risks today versus even a year ago?
Thank you, Sophia. Yeah. One of the first insights is the regulatory trends. We have moved away in the last few years from an encouragement to disclose, where it's now mandatory. And those mandatory disclosure notices have more precise thresholds and timelines. You still have some that are, you know, promptly or when possible and down to, 72 hours under the GDPR, or, 72 hours for your 8K SEC notifications. In Quebec, Law 25 has introduced a stricter regime there, much more in line with the GDPR, and notice must now be given promptly to the regulators, which is the CAI in Quebec, and also the affected individuals if there's a risk of serious injury. Now, this is substantially similar to the real risk of significant harm, the Roche test under PIPEDA, but you also have to be, seeing what's going on globally, right? Your organization isn't just beholden to the jurisdiction where your organization is, or even your direct customers. If you're in a B2B situation, the customers of your customers, if you have their personal data and they are spread out around the world, that means that likely those jurisdictions are in play. Another key, change around is just making sure that you're not falling into any of those privilege pitfalls. The best thing is to assert privilege early. You don't want to wait too long. It can expose findings. There's times and places where I've come in 72 hours late to an incident, and having to play catch up and redo a lot of work in that time period while you're also trying to advance. You want to have legal counsel in place as a breach coach so that, we can direct both forensics and communication work and recovery work to ensure that those reports and the work ongoing is protected under privilege, up until we have to do any disclosures and reporting. And finally, I think there's a big pivot now from a reactive response on everything to proactive. It's incredibly important that the breach coach is no longer just an emergency contact, one or two lines on the incident response plan. But we're involved in breach readiness planning, the table talk exercises, other internal policy reviews. You want to think of breach counsel as the architect or the quarterback. We're helping to reduce your regulatory exposure before anything goes wrong, and then also play between technical and the insurance component as well.
And regarding that technical aspect, Jarrett, from your vantage point on the technical response side, what are some of the major threat patterns you're seeing right now, especially in industries like financial services or education?
Yeah, I mean, there's some clear patterns across those sectors and others in critical infrastructure. And I think just to echo back what Sean just said, right? We're seeing a shift purely from reactive response, so calling us after the breach, to proactive incident readiness, right? So that we're ready when the time comes. More and more organizations are realizing things that they need to have an incident response plan. And more importantly than the piece of paper, that they have to have the tabletop exercises, the playbooks, retainer relationships. They're not nice to haves anymore. They're absolute must haves for operational resilience, right? And as far as like real cyber threats right now today, I think ransomware is still king, and it's evolving. And we're seeing faster encryption cycles, more double extortion schemes, and exponential costs rising year over year. And I would say in close second place is business email compromise. It continues to hit our organizations really hard, especially where awareness, MFA, zero trust is missing or is poorly implemented. And I would say last but not least is supply chain compromise. It's the silent killer. Bad actors are leveraging third parties like SaaS vendors and the SI partners to slip through the defenses undetected. So the critical takeaway from that is that cyber hygiene matters more than ever now, right? Organizations that invest in basic controls, like through enforced MFA or zero trust or immutable backups, active EDR, and ransomware protection, they consistently recover faster and suffer less damage. They win the risk management game, if you could call it that, right? It's really the lack of basic cybersecurity hygiene that creates the opportunity, and you have to proactively be ready for that next incident.
Thanks so much for that overview, Jared. Sean, you had previously touched on sort of how the three areas of expertise sort of come together, but would you mind elaborating a little bit on the role of each cyber insurance, incident response, and the breach coach? And I know some organizations may have one, two, or all three in place, so it'd be really helpful to get a quick overview of how these services differ and complement each other. I also do appreciate that is one of the questions that just recently popped up.
Yeah,
Could you?
I just saw that as well.
Yeah.
Yeah, no, thank you. Yeah, so first off, cyber insurance, can be, labeled as a financial safety net. It covers costs like, legal, breach coach, our work there, the forensics and incident response, technical response, public relations. It also include credit monitoring and the notification process. That's part and parcel with the regulatory reporting. Depending on your coverages, that could also include something like business interruption insurance. But there are some aspects that can void coverage, which you want to watch out for. Delays in notice to your insurance, unauthorized negotiations in terms of ransomware, and then using non-approved vendors. So it's important to, both reach out early or preemptively beforehand and have those vendors in place, but also then to quickly give notice, in case there's an incident ongoing. In terms of an incident response retainer, that's your direct line to technical responders for forensics, containment, and recovery. Here, speed is key, right? Both proactive and reactively. Having the retainer in place means faster triage, likely less damage. You got, the environment, the escalation paths and the legal frameworks that the organizations utilize. But a key here is that structuring that retainer is key. If you have ongoing services, then likely a new contract will have to be signed. A tri-party agreement is typically, the case, so that it's the IR team is working at the direction of the breach coach and legal counsel in order to establish privilege over that work and not get previous work conflated with the actual response to the incident. And then finally, myself, the breach coach, we orchestrate the legal strategy from the kickoff, privilege notifications, regulatory engagement, communications. These communications, internal comms, external comms to customers, stakeholders, vendors, impacted individuals, regulators, and typically, on the bigger ones, the media. Here is where we sync the three together. The breach coach bridges insurance and the technical teams, keeping all the actions defensible, compliant, and underprivileged as much as we can. So there's a lot of communications back and forth, bringing information, distilling, and disclosing the correct information. So outside of that, the retainer with a breach coach gives a lot of that speed and ability to work quickly, same as the IR retainer. And together they form the incident response triad, which covers critical ground. And without one leg, that stool will collapse.
Excellent. Thanks so much for that clarity, Sean. It's very much appreciated. And I think it goes to that old adage, an ounce of prevention is worth a pound of cure, in terms of having those all lined up already. So let's shift gears and step inside the war room. We're going to walk through a mock cyber incident at a mid-sized financial institution, a ransomware attack that begins like so many do on a Monday morning. Employees at a financial institution can't access their shared drives. An IT admin finds a ransom note demanding $500,000 in crypto. Systems are encrypted, and customer information may have been exfiltrated. A member of the security team gets a call from the IT admin, initiates the incident response process. The CISO pulls up a copy of the cyber insurance policy, concerned about the potential missteps that could lead to denied or reduced payouts. Let's walk through the first 72 hours of this breach together and hear how each of you would respond, starting with the first hour, discovering containment. So, Mohammed, assuming this business has a policy in place, what's your first move? Who needs to be notified, and what documentation matters?
Thanks, Sophia. That's actually a good start off. Well, assuming the insured or the client has a policy in place, who needs to be notified can be very important. And actually, as everything we were speaking about from a proactive or reactive stance comes key and critical here. If you're proactive and you had an incident response plan in place, which you had a retainer in place for a breach coach, a forensics firm, or any type of response firm that you require to have working for you, then you would want to notify your breach coach immediately. Subsequently, at the same time, also notify your broker. Just make sure that your broker is working hand in hand to ensure that all the parties that are involved in the case or the matter at hand are working effectively, acting as a middleman per se. If you don't have an IR or you don't have anybody retained, you need to notify your broker as soon as possible, and that's where that whole delay in process can get into place. The insurers typically have pre-selected breach coach lawyers in place for you that you're going to have to be going with, but assuming your counsel or your organization doesn't want to work with them or wants to select their own, and then all of a sudden you're going to be delayed because you have to have your broker request that they get approved on the actual schedule of the policy reactively as to having it in place proactively. So your broker is number one in any scenario, but if you have a retainer in place and you're proactive, breach coach.
Excellent. And maybe with that said, Sean, from a breach coach perspective, when does legal privilege begin?
It begins right away, right on that first call, the kickoff call. You want to make sure that, we're involved and from that kickoff, but also you don't want too many informal group chats. We don't want to disclose any information and waive privilege over any information if non-essential people are included. There's two ways that we go about doing this. Like I've mentioned before, tri-party agreements, with the insurer, the breach coach and the forensics teams. This avoids delays and preserves privilege. And essentially all the documentation flows through counsel. Breach coach, also sometimes called a quarterback in the situation. Most of the team is playing through there. The other important thing is to keep the circle tight. These early discussions should only involve the incident response team, including forensics vendors, counsel, and senior leadership. We want to avoid those premature disclosures. And during the triage call, when we set them up, typically I like to, after the introductions and figuring out who everyone is, not just from their role, but also from a legal perspective. If they're an employee of the organization or a third-party vendor, then there's certain components that we have to do, especially if they are a third-party vendor. Sometimes we got to bring them in under a tri-party agreement again. But from there, after those intros and rules, I like to start with what happened technically. So, I'll leave it at some point to Jarrett to go through a lot of technical questions. I may interject as there's sometimes we need to either have a conversation go a certain way, or I've identified some risk and want to tease that out. But once we've figured out what technically happened, there's a lot that has to happen from an IT and incident response perspective for the technical team. So I'm going to let them go and get that sorted, maybe figure out scope and the finalities of the contract if we need to get that in place. And then we're going to start talking through, communications, regulatory requirements, crisis management steps, and providing that initial legal advice on how to respond to the incident. So as we go through that kickoff call, the number of people on the call will get smaller and smaller.
And Jared, from an IR perspective, what are the first technical steps?
So if we're in the war room, right, I want everybody to consider that the initial breach or the intrusion, it didn't happen yesterday. It didn't happen last week, right? You have to consider that the bad actor has been on the network for 6 to 9 months in the typical intrusion, right? That's the time it takes to make a baby. Think about that for a second. So you have to assume they know the network and how you operate better than you do moving forward. So what that means is the first few moments after the discovery are absolutely critical, because whatever you do or you fail to do within that window is going to determine how bad this incident gets, right? So the first technical move is containment. It's not eradication, it's not investigation, it's containment, right? You're not thinking about the who, the why, the when, the where, the how. That's all noise. Attribution, motivation, timeline, that comes afterwards. Your focus is on the what, right? We want to see up on the board, what do we have? Like, what do we know, right? What indicators do we have today? What systems have been affected? What data has been exposed? And what do we need to contain first? That will determine what you do and the sequencing, the order of priority that follows after that. And at the same time, inside the war room, we're managing how we're going to preserve the evidence, right? You need to be able to reconstitute the story at a later date. So it's incredibly important not to wipe or alter the systems at this stage. So the key takeaway I have for the first couple of hours is contain fast, protect the evidence, and activate the right teams immediately. The clock certainly isn't our friend in these first initial hours. Being ready is, right?
Yeah, and if I may, I just want to echo that point on preserving the evidence. As much as we want to act quickly, we do have to preserve the evidence, because otherwise, if we have nothing really to look through, then unfortunately, I'm going to be, working backwards in terms of what we're going to do from a regulatory and notification perspective. I want to take off as much as I can, and leave as little as possible. But if I have no evidence to do that, then I'm stuck looking at essentially the whole pie.
That's a lot to cover off in just the first 1 to 3 hours. But I'm sure everyone can appreciate, again, the value of having these conversations up front and having a plan in place, right? So moving on to hour 4, assessment and coordination. Jarrett, let's say your team is on site. What are you trying to learn in those early forensic sweeps?
So in hour 4, right, once containment is underway and the immediate threat has been stabilized or their effects neutralized, the focus shift towards forensic analysis and coordination. And again, the first priority of the forensic sweeps is determining the breadth and the depth of the scope here, the incident, and preserving that story. We're asking questions like, were critical services impacted? So anything first and foremost that's related to life, safety, operational continuity. So say we're in a healthcare or a hospital setting, right? We're concerned about lives. We're concerned about patient safety. We're concerned about, the reliability of the systems in the OR, in the ICU, and even supporting systems like scheduling, right? And that carries out through different sectors as well that are in critical infrastructure. So take transportation, for instance. It doesn't matter whether you're on a boat or on a train or on a plane, right? It's life, passenger safety, and reliability of those systems. We're having a really bad day if the navigation systems have been mucked with, right? Or traffic control, right? That's a really bad day for us and for our clients, right? Following that, it would be really about what systems and data have been accessed, right? What credentials have been touched, what data has been accessed. We're trying to collect as much information as possible and determine, has that data been exfiltrated? Has it been packaged up and shipped out the door? And if so, how much of it, right? And then from there, we're looking at, well, what kind of data was that? Was it personal information? Was it health-related records, financial information, intellectual property, export controlled if we're dealing with defense data, right? Or is it operational data that we need to think about? All of that really drives everything in terms of the legal obligations, breach notification, insurance claims, and how you're going to manage that internal and external messaging. We try to boil that up for the breach coach and the insurer, right? And at the same time, we're coordinating that forensic evidence. We're capturing the volatile memory on the machines or the affected endpoints. We're pulling system application logs and looking at network traffic, and we're imaging affected systems for deeper analysis. It's important, again, to echo what Sean said earlier, that we're doing so in a careful and a systematic manner. That is the definition of forensics, right? We want to make sure that we have the suspect drive and 3 copies bagged and tagged. So the suspect drive and the first copy is in the vault. The second copy is to the RCMP, depending if there's criminal implications, right? And the third copy, we're working from that. But the point is, it's bagged, tagged, signed off, and the forensicators have a working logbook open where they're basically detailing date, time, what they did, and initialing beside it. So why that's important is at a later date, when you're sitting in the hot seat in a court or in front of a tribunal or a hearing, you need to be able to recount that step by step and the actions that were took and also the inactions as well. So, again, the key takeaway here is get the facts without disturbing the evidence, preserve the story, the environment, is really telling us at the end of the day.
Thanks so much, Jarrett, for that comprehensive walkthrough, especially regarding the chain of custody. There is one point that I wanted to draw on a little bit further, and maybe Sean, this is a question for you, is regarding risk articulation, right? So, if we've got personal information involved, what is the real risk of significant harm, and how does that come into play when working through how to assess what triggers notification obligations to regulators?
Yeah, thank you. So, ROSH, or the real risk of significant harm test, is PIPEDA standard. There are very similar ones across the jurisdictions, which essentially lead to you assessing risk. There's key factors when you're doing a ROSH test. The type of information, in our case with a mid-sized financial institution, you're likely dealing with social insurance numbers. You'd have other financial data, could be information around, people's properties, their livelihood, their assets, monetarily and otherwise, if they're getting a mortgage or anything of that sort. If we're dealing with a hospital, there'd be health information, which also could be included in the financial institution if they're also looking at some sort of policies, maybe an insurance policy, life insurance policy, something like that around assets. So that's one of the main key factors when you're dealing with what the risk is. Obviously, social insurance numbers or other very sensitive data like biometrics is something that can't be changed, or definitely can't be easily changed. Another key factor is the likelihood of misuse. Was this exfiltrated in a ransom event? Was it synced in terms of business email compromise? There's a big difference between syncing an entire email inbox so that threat actor essentially has a copy of that entire inbox, or did they only access maybe 10, 20, 30 emails? And that's something that the logs and something that Jarrett's looking for in that forensics evidence is pulling out. And like I mentioned earlier, if those logs aren't there or they were deleted, and I can't tell if that email inbox was synced or not, unfortunately, the default is it was synced if there's nothing to tell me otherwise. If there's a difference in the logs of how they logged in, if they logged in, just on the browser, or if it was synced to the app, the typical area. And I leave that to Jarrett to determine and advise me, so that I can provide my advice. Another key factor I touched on earlier, sensitivity of data, and then the mitigation efforts. And now this is mitigation both proactively in terms of what you did to protect that data before the incident, but also the steps you've taken after. So as Jarrett mentioned, putting that information down, understanding what you did, when you did it, what you didn't do, and why you did it or didn't do it, is important for those mitigation efforts. There's a few different reasons to assess risk. Law 25 in Quebec and PIPEDA have different requirements, but it is not just waiting for the evidence of misuse. Likely, sometimes we don't have evidence of misuse, and often we don't. We just understand that it is likely, based on what has happened and what has occurred, or where that data is gone. Also, I think a few weeks ago now, the OPC came out with a new ROSH test form on their website. It's actually pretty good. I've used it a couple times myself. But when you do use it, you do want to keep a copy for your records of the results, but also, have an expert, or the breach coach either complete the test or review the results. We've mentioned a few times, and as we're on hour 4 here, the clock is ticking. It's not our friend, but the notification clock doesn't necessarily start ticking yet. It does start ticking when that ROSH is identified, not when maybe the breach is confirmed, but when we have the understanding of what data has been impacted. In Quebec, notification must be prompt. Now that is not a 72-hour or 48-hour hard stop, but it's also not after weeks of deliberation. The longer you wait, the more likely you are going to have to explain yourself to the regulator. And finally, it's important to be both thorough, but also precise. The regulators are going to want accurate timelines, scope of impact, remediation efforts. And if you are missing details that they are expecting to see, that can lead to further scrutiny or enforcement action.
Thanks so much, Sean. So we've heard a fair. Oh, sorry. Go ahead, Jared.
Sophia, just maybe to drive something home, right? So during hour 4 in the incident, like in the war room itself, the pressure is mounting, the internal pressures are mounting, the external factors are mounting as well, right? So again, it's really important to collect that forensic evidence to understand what happened, but also to defend the organization and our actions, inactions later, right? Whether it's with authorities, regulators, partners, customers, and the insurers. It's absolutely critical. And I think for the audience, Sean, it might be helpful just to throw an example, because of biometrics. Like, what would be biometric that they should be looking for on the network, right? How would you guide that team? What are we looking for? So like a
I've seen it.
passport or
Yeah. I've seen it a few times. Actually, one of the big examples that I see is in retail shops. The individuals logging in will use their thumbprint in order to log in. Now, that's obviously saved somewhere on their system. I don't know if it is like an iPhone where it's just on your device, or if it is going back somewhere. So that thumbprint would be one of them. Obviously in some higher tech institutions, they might use, especially if you're dealing with national security, something like that, might iris scan, facial rec, stuff like that. They do even use that in financial institutions. There are probably some other examples there as well.
thank you.
So thanks for that, Jared. We've heard a great deal in the section about evidence, and Mohammed, I'm wondering, how do these early findings connect with what's covered or excluded under a cyber insurance policy?
Thanks, Sophia. That's actually a really good question. And if we go back to, let's say, hour 1 in the incident, from the immediate awareness of a particular incident, if we just look at coverage from the standpoint of how the multiple policies that are out there in the market currently are written in their policy wording form, you can just basket it into 3 different sections. You can look at it from a restrictive policy, a basic policy, or a comprehensive policy. Now, that can mean many different things in each basket, depending on which insurer you're dealing with and the type of policy wording you're dealing with. But as a client, it's not your understanding to be an expert in cyber insurance wording. So working with a cyber specialist broker is key, because clients are relying upon the cyber insurance specialist broker to tell them what those nuances between the different languages of the different policies that are out there are. Now, where we do run into a situation where clients are kind of frustrated between whether a claim is covered or uncovered is when we go back into that proactive or reactive stance. From hour 1, when you discover an incident, if you don't have a scheduled incident response vendor, forensic vendor, or a breach coach counsel, and the Friday you get hit with let's say a ransomware event or an incident on a Friday evening, from hour 1 to hour 6 or 7 is very, very important. And oftentimes those teams or those organizations are going to start working throughout the weekend before the insurance company or even the broker is made aware of it. And where it becomes a situation is, they're taking on billable hours, and those billable hours may not be an approved vendor for that particular insurance company. Some insurance companies only like working with certain vendors, where others are open to working with multiple vendors. If you are proactive, your broker can actually specifically request that a particular vendor that you want is scheduled onto the policy, even though it's not a particular vendor that insurer may want to work with. So the insurer may actually look at it as a gateway to maybe not pay out that particular vendor and maybe switch the vendor on you, 48 hours later. And all of a sudden, any costs or billable hours are incurred throughout that duration when they were trying to do containment is up for a dispute or up for negotiations with them. So again, working with a cyber insurance specialist to be proactive and making sure that those things don't occur to you is critically important. But then also making sure that the broker explains to you what your coverages look like if they are restrictive is key. I can tell you, during the hard market cycle, during COVID, when market rates were going up, the cyber insurance industry was kind of up in arms because the claims were just coming in significantly. There is a lot of restrictive language that's out there that needs to be reviewed, and coverage limits need to be increased with that restrictive language and made more comprehensive. So working with a cyber insurance specialist, working with the breach coach lawyer, working with a forensics firm or incident response firm is key in those early hours, because that will determine how the claim payout will look like in the end, and what the settlement will look like in the end.
Mohammed, I do have a quick follow-up question for you. Who should be calling the broker? And I think number two, I'd really be interested to understand who ends up calling the broker most often in practice.
In practice, it's every client, every business is different. The person that calls the broker is the individual in the organization who has the relationship with the broker from the insurance placement standpoint. That can be the CFO, the controller. It can be an insurance manager. It can be, many different people in the organization, depending on the type of organization that we're dealing with. But a good cyber broker will work with that contact person at the organization and their head of IT. Or sometimes if they have a head of IT, or if they have an in-house CISO, we'll work with the CISO very closely. Or if they have an external IT service provider, we'll work with them as well, to make sure that everybody is on the same page and there's kind of a communication of understanding of how to go about the situation. So the most important thing is the CISO or the head of IT or the client contact with the insurance placements for the overall business, not just the cyber placement.
Yeah.
I think so. Yeah. Oh, sorry,
If
go
I
ahead,
could
Sean.
just pull on there, I find sometimes in practice too, towards the end of a kickoff call, if it hasn't been established already, I'll ask about cyber insurance. Sometimes clients have it, don't realize it. Maybe the CFO is away on holidays, not there, or they have a small policy. So sometimes it's about, figuring out what they do have, maybe, taking a quick look just to see what titles are there and see if we have to notify. So there's times I've had to, notify on behalf of clients, the broker or the insurer directly to figure it out, maybe what policy is involved. So sometimes it's not nice and easy, and preparation would have been a little bit more helpful there, and some redundancy as well. But it can come from all different scenarios, and obviously best is to go through the broker to the breach coach and get going. But sometimes we do go in a little bit of a circle.
And a lot of that stuff can be avoided by just working with your broker when you're
Yeah.
developing your IR plan. The amount of organizations that are out there that have incident response plans developed but have never engaged their broker or their insurer with it is significant. And the best way to avoid all of this is when you're developing your IR plan, engage your broker, work with them, just to make sure the right parties and the right individuals are listed there, and that the policy is in line with those individuals that have been selected. And that can make a world of a difference, from having a complicated claims process or a very smooth claims process.
And I would just also add to that if the client has an IR retainer in place with an external firm, to make sure that they work with the broker and insurer to name that IR firm as well in the policy, right? There are certain cases where the insurer, the broker, will want to use their own IR firms, right? So even though you've got that retainer in place, right, they have to take a back seat to the insurer's preferred IR team.
This is great advice. Thanks so much. And maybe returning to our scenario very quickly, moving into day 2 to 3, communication and recovery. Sean, when you're advising clients on public and customer communication, what are the do's and don'ts?
Yeah, so there's a few do's and don'ts, and then there's 4 things that I'm going to go through for vetting communications. In terms of do's, you want to be truthful, measured, empathetic. Many people kind of miss that last one. You want to give some reassurance, but without overpromising here. I say that, and then you have to tailor the messages by the audience. Are you talking to regulators, clients, internal teams? Although they are tailored, you want to have a level of consistency that is also in line with the organization's day-to-day communications, either internally or externally. So there's many times during an incident, and this was typically before it's become a breach, when we're working on that communication. It could be drafted by someone internal to the organization, especially if they have a comms person, or a person that typically does the communications, and then it's edited, right? You don't want it to come off sounding like it comes straight from a lawyer's mouth. You want to have that level of consistency from the organization. That being said, you have to work with legal, PR, and the technical teams as well, right? To align on the facts and tone. You don't want to speculate. The the line of "we believe no data was accessed." Now that's a trap that is going to be, a bit of a landmine if it's proven false later. You don't want to delay your communications. Here we're on day 2, 3. Sometimes this could be, in terms of our scenario, it started Monday morning. We could have communications out by Monday afternoon, Monday evening even, or it could be first thing Tuesday, depending on how the incident is played out. Regulators and the media move faster than your comms team. And that's, a typical scenario. Also, you want to, again, avoid tech jargon or legalese. That harks back to my points of consistency and like it's coming from the organization, while clarity builds trust. Confusion erodes it. And also you are going to want to lean into the reputation and trust that you've built as an organization preemptive to this incident. When I'm vetting communications, there's 4 things I'm looking for. These facts, are they accurate and clearly described, or are you making assumptions and speculation? We want to avoid assumptions and speculation, as those can be traps for later. Are you making commitments or promises? Promises should be made sparingly and with intent. You have to make sure that those promises are achievable, and because you've committed your organization to a timeline that may not occur. Forensics, recovery, data discovery, they all take longer than anticipated almost every time. It is better for your organization and the people doing the communication to under promise and over deliver. I can't stress that enough. And are we accurately conveying the risk? Here is my third check. Are we raising the alarm or encouraging action? Is that justified in what we want to occur? Or are we causing stress for no good reason? There's a level of walking that tight line there. And then finally, again, we have to worry about privilege. Was any of the communication reveal anything that was said under privilege? We don't want to waive it by mistake, especially if we are going to have to disclose it later. You don't want to preemptively disclose it. You also don't want to trip over any potential landmines there.
And Jared, assuming systems are still down, what does a recovery timeline look like, and how can it be accelerated, if at all?
It depends heavily on 2 factors. How well prepared are the backups and how disciplined is the recovery plan, right? Best case scenario, if we have clean backups, right? Meaning that they're tested, they're offline, they're uncorrupted, right? They haven't been compromised, and the incident is properly contained, then you're looking at a stage recovery over hours and days, not weeks and months. We typically prioritize critical services first and bring them back in controlled ways, not all at once. And I would say, on that note, it is critical, like in every organization that we step into, if you want to accelerate the recovery, right, and minimize the damage and get the business back up and running as quickly as possible, you have to have a prioritized little list of critical systems for us and recovery sequences ahead of time, right? So we know what needs to come back online first and in what pecking order. You have to have good, clean, golden images of those disks, right? And playbooks for restoring that infrastructure. So basically trusted images, right? And the exercise in terms of how we're going to bring this back up, right? And then we have to be able to coordinate closely with legal and all teams, right? To time the restoration and, more importantly, the business resumption and the internal external messaging that has to happen with that. And it really is a team effort. It's not just a technical problem at that point, right? It's a lot of juggling at the same time. Lessons that I've learned, excuse me, from real world IR incidents, right, is unverified backups are a huge pitfall. They often get restored only to find that they've been compromised too. And I would build on that. I can't tell you the amount of times that, I've been on my knees in a data center, crying, bleeding, sweating, freezing, right? Going through a bunch of boxes at Diamond or in a data center trying to find the right backup tapes. In some cases, we're going back 9 months, right, to find the right order, and they don't have labels on them. They're not cataloged. It's really hard to rebuild those systems without that map. So to consider that. And then another big one is rushing to rebuild the infrastructure without forensic clearance, right? You can end up actually reinfecting the environment and your data over and over again, just resetting everything back to zero. And then again, the biggest one is the lack of communications between technical executives and legal teams. It will delay the decision making, and every hour that we lose increases the business and the reputational risk, right?
Thanks so much
It
for
really
that.
isn't about like flipping switches. It's a controlled forensic rebuild to facilitate business resumption and get them back online completely and accurately as well.
Yeah, I think, there was one time, and if I may, there was one time I was brought into an incident 72 hours in. That is the point now of everything that we've talked about. We are now at, basically 72 hours. This was when I was brought into an incident. It was being handled by the organization and the external IT. And I was expecting to have this late kickoff call to be confirming, what has been done, what has been taken. And I was asking questions and getting answers like it was hour one. So we were having to then work from, we were 72 hours in the hole, behind the eight ball, working our way out. So we had to quickly, establish teams, bring in external, you know, both, a separate forensics investigators and recovery team. You're dealing with a lot of both IT and OT infrastructure for this client. And we were dealing with what turned out to be a double ransomware scenario where there was two layers of ransomware, two different ransomwares on top of each other, which was going to likely screw up recovery, of those backups. And then actually got to the backups as well. So we were without any viable backups. We actually had to go and figuring it out from a technical perspective while also reaching out and trying to engage the person who built the OT system. It was a proprietary system, and get a copy of that because we had no viable backup for this system. And as I said, it was proprietary, so you can't just go purchase it off the shelf anywhere. Thankfully, the person who built it had an instance from when they had updated it about 2 years ago. Now, it wasn't great that we were losing 2 years worth of data. But it was better than nothing. And honestly, if it wasn't for that, the company might not have been able to get back into business. From their perspective, this was a family office, and they also had quite a large amount of physical records, printing things out, doing things, by hand. So there was many different, nuances to this. And one final point is they had an O drive that had what I think was every time they scanned something, it got saved to that drive. So just a mirage of data going back 20 years. We thought they weren't going to have to do much notification because of things were either offline, like HR and employment data. But then this drive that was 20 years old, and there was ex-employees' tax returns and whatnot. So then we were notifying people that hadn't worked with the organization for 20 years, all because this data was saved and unfortunately wasn't purged a long time ago when its use was turned to zero.
Yeah. Thanks so much, Sean. I did have a question for Mohammed. How does your role shift from response to resolution, and what does insurance want to see before paying out? Because I have seen a number of questions related to that on our chat.
Yeah, Sophia, that's a good question as well. I mean, if you look at it on a broad spectrum of what happens when clients are, dealing with cyber attacks, organizations are continuously, facing cyber incidents. Some of these incidents may not be material, and maybe an incident that got retained, there was no exfiltration. And then some of these incidents may be very serious because it wasn't contained right away, and maybe it did some lateral movement, and it got into the whole network, maybe half the network, or just a few laptops or a few areas of the network. Whatever happens from when the threat actor got into your environment, and then from when the organization was able to respond to it, some of these incidents need to be materially disclosed to the insurer, and some of them need to be investigated before they need to be closed out. How do you make a distinction as to whether an incident is material or not is where reasonable effort needs to be made by the client to showcase that they did everything they could to be forthcoming about the severity of that particular incident. A lot of organizations try and do it themselves. They don't even speak to their brokers about it. And we say that's the wrong thing to do. It's always best to consult counsel. So talk to your breach coach. They can give you the advice you need in order to determine if that incident is material, if it needs to be investigated, and if it needs to be investigated and is material, if it needs to be reported to the insurer. So going back to it, making sure that you're working with your breach coach before you make any decisions on your own can be helpful. And don't be scared to talk to your breach coach. You're protected under privilege. They're there to guide you and advise you. And they're there to ensure that you aren't misrepresenting and that you're not getting yourself caught in a mousetrap. Because ultimately, if you try and do it on your own, 9 months from now, a year and a half from now, it becomes material. Now we're, walking into a situation where we have delayed reporting. A lot of these cyber insurance policies, not just a lot of them, every single one of them is a claims made and reported policy, which means if you do not report your incident within the policy term, that 12-month policy term, it may not be valid and reportable as a claim action after the policy is renewed. So every year when you're renewing your policy, you need to make sure you have a list of every incident that's occurred throughout that year, either reported to the insurer or notified to the breach coach to determine whether it's material or not.
Excellent. Thank you. Thank you so much for that guidance, Mohammed. I do appreciate we are entering the final stretch of our time here, but I did want to wrap up this session with some reflections in terms of your experience, and maybe wrap up with a couple practical takeaways for our audience members. Could each of you maybe provide a handful of key takeaways for our audience? Maybe Mohammed, we can continue with you because I think it's such a good note to pick up from. What should businesses do right now to optimize cyber insurance coverage and avoid unnecessary premium hikes?
Yeah, so cyber insurance coverage works in different ways, but obviously when you're going to a market and you're getting your cyber insurance underwritten, they're looking for critical areas that showcase that you are a resilient organization. And the best way to showcase that you're a resilient organization is by demonstrating that you understand the 3 areas of importance, which is people, process, and technology. So governance, policies, good technology, products and services that you have available that are helping you defend yourself as you're continuously facing cyber incidents or the onslaught of a cyber incident. But not only that, having your policy reviewed by a broker specialist who understands the market, and not only just understands the market, but understands the products that are available in the market to optimize your coverage that's available to you, and then also optimize the premium that you're getting charged. Keeping up with market cycle trends. So, if rates are falling, maybe it's a time for you to take advantage of that and remarket your insurance policy. If you've only been with that insurance carrier for 1 year, maybe you want to maintain continuity with that particular carrier and not remarket it, but just making sure that you're making decisions in a way where it's not just in the best interest of the insurer, but it's also in your best interest, and it's in the interest of where the market is heading at the moment. Can very much help you out. At the end of the day, your total cost of risk, it does include your insurance premium, not just your IT spend on security. And making sure both work together is the best way for you to be on the best side of those opportunities, but also to give your organization the best ROI per se.
Thanks so much. And Jarrett, what are 1 or 2 preventative controls you would prioritize for any business, regardless of size?
I don't think I would. Preventative controls. I've been doing this for 25 years for national security and critical infrastructure, right? I don't believe controls and tools are what helps get you through an incident or to recover or resume your business. What you need to do at the end of the day is you need to invest in your capabilities, right? You need to build that in-house capability and exercise that muscle memory. So what I would leave the audience with is go back to frameworks like NIST 2.0. Make sure that you've got good cybersecurity hygiene in place, right? And that you're working towards your cyber incident readiness. If you're already there today, then good for you. Start focusing on the next capability, right? Which is basically defense. I kind of want you to pull from the MITRE Atlas. You can go download the toolkit. You can go to MITRE Defend as well to really start thinking about the shift in mindset that needs to happen, that we're not waiting for the breach to hit us before we're doing something about it, right? We're taking proactive measures. We're putting those measures in place so we don't have to respond, right? Because we were able to detect early, we were able to disrupt the threat, right? We were able to deny access before it became a problem. So again, go back, look at NIST 2.0, try to align with that. And then also, look at MITRE Atlas and MITRE Defend and build out those capabilities.
Yeah.
Yeah,
I think
to Jared's point there, actually, insurance companies are aware of that. They know it's not a matter of if it's going to happen, it's about when it's going to happen. And they just want you to showcase that you're not a sitting duck and that you're following some level of framework, whether it's NIST, SOC 2, ISO 27, all the various frameworks that are out there that are available to you, and that you're following them to an extent where you're showcasing that you have some level of resilience. So they're aware of that, and being proactive there is critical.
Yeah, I think there's a few things proactive to build resiliency. Privacy program reviews, tabletop exercises, not just technical tabletops. Those are important, but are you also conducting tabletops with management, with the executive team, and also with the board? Don't forget the board in that. My other last point is a clear chain of command. We need to know who's calling the shots and when, depending on what it is. It could be legal, the IR lead, CISO, IT team, whatever it is. But you need backups and seconds in command. Many incidents are taxing on these people, but also they happen at the worst possible times. People are on vacation, they're out of reach, they're away, they're on leave, or whatever it is. And also these incidents require around the clock work, and we don't want people to burn out. So we need the people involved in response to recover to be at their best so that we can have them rotate in as possible. And finally, to have these defined escalation paths, they both need to be defined and stress test. Really, it's about building that muscle memory and that resilience so that you can do this well, and then also, be able to reap the rewards and the ROI from both technical and the cyber insurance perspective.
Thanks so much, Sean, and thanks to all our guests today. You will be able to get in contact with our speakers. Their contact information will be shared after the session and via Andrew Fraser. So thank you again to everyone for your expertise today. This was a really insightful discussion. Thanks again.